Welcome to the Supreme Court Podcast.
Can a bank be found negligent for allowing unauthorized withdrawals? This was discussed by the Supreme Court in the case of BDO versus Seastres, GR number 257151. In this case, Liza Seastres, a business owner and BDO depositor, discovered that her chief operating officer, Annabel Benaje, made unauthorized withdrawals totaling over 8 million pesos. Liza sued Annabel and BDO for collection of sum of money for allowing the unauthorized withdrawals. The regional trial court ruled that BDO failed to fulfill its obligation to treat Liza's account with extraordinary diligence. The RTC ordered BDO and its branch heads to pay Liza over 8 million pesos in actual and moral damages. It also ordered Annabel to indemnify BDO and its branch heads. The Court of Appeals also found BDO negligent, but ruled that Liza must bear 40% of the damages for her own contributory negligence. The Supreme Court upheld the finding of negligence on BDO's part, but ruled that Liza was not negligent. As a business affected with public interest, and because of the nature of its functions, banks are obligated to treat the accounts of their depositors with meticulous care, always considering the fiduciary nature of their relationship. In Liza's case, BDO was duty-bound to exercise the highest degree of diligence in handling her bank accounts and ascertaining that Liza made the signatures on the withdrawal slips and manager's checks. However, BDO failed to comply with its own rules and regulations, which require withdrawals made by a representative to include the depositor's written authorization, which the bank teller must verify. This was not followed by BDO when it allowed Annabel to personally transact the unauthorized withdrawals without first confirming with Liza Annabel's authority. While there allegedly was a written authorization in favor of Annabel, it was limited to deposits, inquiries, pickups, and printouts on Liza's behalf. It did not authorize her to make any withdrawals. BDO breached its contractual duty to Liza when it allowed the encashment of managers' checks despite the fact that the payee in the said checks was Liza, but the person encashing them was Annabel. On whether Liza was also negligent, the court found she showed vigilance when she immediately conducted an investigation on suspicious withdrawals. The Supreme Court thus ruled that for its negligence, BDO is solely liable for over 8 million pesos in actual and moral damages, attorney's fees, and the cost of the suit. To read the full text of this case, visit the Supreme Court website and search for Banco de Oro Universal Bank Incorporated versus Seastres, GR number 257151.